Hi, it's Ken. And this week I wanted to talk about a question that I get from clients all the time. And it's a basic question, but it depends really on their situation. So there's a lot of follow-up questions. But the basic question is, how do I title my assets? And there's lots of different ways to title assets. There's lots of different reasons, and it really depends on their situation. So when you talk about titling assets, there's really three ways to own property. It's yourself, you individually own it, jointly held property, and contractual, which means I have life insurance and I designate a beneficiary, or I have a checking account and I designate transfer on death beneficiary. So those are contractual, which means as soon as I pass away, those assets automatically go to the beneficiary I name. So a lot of questions say, well, my parents passed away and it was a mess in probate court and it took forever. I want to avoid that as much as I can. So, yeah, can you name, transfer on death beneficiaries for all of your bank accounts, investment accounts, even your house? Yeah, you can. But there's still a transfer issue that when you pass away, there's still deeds that need to be filed, and there's still trips to the bank with a death certificate that need to take place in order to transfer that. And depending on your estate plan, the bigger issue is in your estate plan, if you have two children and one of them you name as the beneficiary of your accounts or your house, well, you in essence just disinherited one of your children, because if I have two kids and I name the oldest to be the beneficiary on my account, if something happens to me, the oldest one technically gets that account, and the other one, the younger one, gets nothing, and that's a problem probably for most people. So the easiest way to avoid probate court and title your assets while you're alive, and I've talked about this numerous times because I'm a big fan of it, is just a generic revocable trust. Creating a revocable trust, and you can do a joint one if you're married, and going through the process of retitling all of your assets while you're alive will save a lot of time and hassle. We'll avoid probate court, we'll avoid those extra attorney's fees, the court fees, and really it's a transition ease as well, because once I create that revocable trust and I designate or retitle my assets, my checking account, my house, my car, my investment accounts into that revocable trust now while I'm alive, when I pass away, when my spouse passes away, there's no change of ownership, right? The trust is the owner. The day I create the trust and then go to the bank and say, transfer ownership of my checking account to the trust, that's the change of ownership right then and there. So when I pass away, the trust remains the owner. The trust is still alive, it's still in existence, and the trust still owns all those accounts. So now it's just, all right, what are the provisions of the trust? Who's the successor trustee after I pass away? Who are the beneficiaries? So that's an easy transition. There's no probate court period of time where you have to wait for creditors to kind of raise their hand. There's no time frame as far as how quickly the trustee can start distributing those assets to the beneficiaries, of course, according to the provisions of the trust. So when I get the question from clients that say, I want to avoid probate court, what should I do? How should I title my assets? Yeah, creating a revocable trust is probably the easiest way, and it's the most inexpensive. The way I kind of talk to clients is, would you rather spend a few $1,000s now while you're alive and know that all of your affairs are in order, and we're going to go through the process after the trust is created to make sure all of the assets are titled properly, or do you want your kids to have to figure it all out and pay double the amount that a trust would cost now for probate court and all the advice after the fact? And typically that's an easy answer. We'll just pay a couple $1,000s now and make sure it's all done, and we can know that once something happens to us, it's going to be an easy transition. The last thing I wanted to talk about is, when you create a trust, or when you're talking with your accountant or your attorney or your investment advisor, it's really important to understand what assets should be titled to the trust and what assets shouldn't be. So when you talk about a checking account or a non-qualified investment account, your house, your car, things like that, absolutely those things can be transferred to the trust. Now, of course, with a house, if you have a mortgage, that's something that you want to bring up with the mortgage company to make sure that you can transfer it to the trust without some issue happening with the mortgage. But other than that, those are the typical assets that people transfer immediately. When you talk about retirement accounts, life insurance, things like that, you don't want to change the owner of those accounts. If you're married, for retirement accounts, you absolutely want to keep your spouse as the primary beneficiary. There are major tax benefits to inheriting an IRA from a spouse to another spouse that you do not want to give up. But when you talk about the secondary beneficiaries, those can absolutely be your trust. For life insurance, you typically want to stay the owner unless you have a life insurance trust. And in that case, I typically tell clients, yeah, the primary beneficiary should be the trust. This way you know that the assets are in there, and when you pass away, the trust will distribute the assets the way you want them to distribute according to the provisions of the trust. So I hope that helps clarify some titling issues. So if you like this video, like it, share it, and I'll see you next week. Thanks.